Good morning. Thank you for joining us today. Today's very timely topic is the Families First Coronavirus Relief Act, what employers need to know, with presenter Jeff Mandel, attorney of law, Fisher and Phillips. So thank you for joining us today. As it turns out, the world has changed significantly in the last 4 weeks. Looking on the bright side, it has brought us the opportunity to bring awareness to the relevance of online, on-demand training. We hope you will take advantage of these webinars. A few housekeeping notes. As a participant, your audio will be in listen-only mode, using your phone or computer, whichever is more convenient. Additionally, you will have the opportunity to ask questions using the question window. Add your questions there, and we will address those at the time allows at the end of the presentation. This is a live webinar event, which is being recorded. A link to the recording will be provided to you within a few days, and posting it on the Florida Makes YouTube channel. I would now like to turn it over to Jeff Mandel. Thank you, Jeff.
Thank you, Sherry, and thank everybody for joining us this morning. It's my pleasure to present to you this program entitled Families First Coronavirus Response Act, what employers need to know. As Sherry mentioned, I'm Jeff Mandel. I'm the managing partner of the Orlando office of Fisher and Phillips. Fisher and Phillips is a nationwide employment and labor law firm. We represent employers in employee relations and union matters across the country, and we've spent a significant amount of time going over a lot of these new laws and trying to decipher everything for you all. The name of the program is pretty self-explanatory. It's my intent to run through the things you need to know about this new legislation and answer any questions that you have about it. As Sherry mentioned, we're going to hold the questions to the end of the program. I have every intent of ending my talking part of it in enough time that we can answer any questions that you have. I will stay on the line as long as possible. If you have any questions after the end of the presentation, feel free to send me an email. I'm happy to answer them to the best of my ability. But please, I would encourage you that if you have questions, post them. That, to me, is the real advantage to attending programs like this. So, with that introduction, let's go ahead and turn our attention to the Family First Coronavirus Response Act, also known as the FFCRA. And as I'm sure all of you are aware, this law was signed into being in March 18th of 2020. It contains 8 different sections. 2 of those sections of the Act touch most directly on employment law, and those are the Emergency Family and Medical Leave Expansion Act, which the acronym is EFMLEA. Labor attorneys love acronyms, so we're going to use acronyms throughout this. And the second component touching directly on employment is the Emergency Paid Sick Leave Act, or the EPSLA. These were effective April 1 of 2020. They sunset, meaning that these provisions end December 31 of 2020. When the law first was put into being, there were significant issues that existed regarding the interpretation of the law itself. To attempt to remedy those and to provide clarity on what was required of employees and what was required of employers and employee rights, the Department of Labor issued regulations on April 1 of 2020. Those regulations, referred to as a temporary rule, contain 124 pages of discussion and rules relating to employee rights and employer responsibilities. And they answer most, but not all of the questions that exist under the FFCRA. And just to show you how fluid this all is, and the mere fact that the Department of Labor didn't issue regulations interpreting the FFCRA until the day that the act went into effect. Just this morning, the Department of Labor issued corrections to the temporary rule and regulations that were issued on April 1 of 2020. I'd like to hope that that is the end of any changes in the interpretation or application of the provisions of the FFCRA, but as Evans has already shown us, this thing will continue to change over time. So I would encourage you to keep on the lookout for changes in the law with respect to the FFCRA. So with that, let's turn our attention to the first of the two main employment-related sections of the FFCRA, which is the Emergency Paid Sick Leave Act, also known as the EPSLA. So what exactly is the EPSLA? It's a new law that provides a new benefit, new paid sick leave to employees who are unable to work or unable to telework, meaning work from home, for the qualifying reasons that are actually set forth in the Act itself. This is an entirely new law. It's not an expansion of an existing law. And it's very important to understand that the new benefits under the EPSLA are in addition to any benefits required by state law or any benefits required by your policy, such as if you have a PTO or paid time off policy. For those of you who may have businesses in other states, it is important to make sure that you know what state law requires in addition. Again, I'm going to say it because I have gotten this question repeatedly, notwithstanding the fact that I've been giving these presentations and explaining this. The Emergency Paid Sick Leave Act is not a substitute for existing benefits. They are benefits on top of what you are required to do either by state law or because of your policies. So before covering what the new paid sick leave benefits are, we first need to know what employees and employers are covered by the EPSLA. With respect to covered employees, the law covers any employee who works for an employer. It's as simple as it sounds. Independent contractors are not covered because they don't work for you, but if they work for you, they are covered. And importantly, there is no minimum days or hours requirement for work prior to being eligible for these new benefits, meaning that when you hire somebody on, they are immediately eligible for these benefits. What employers are covered by the Act? Any employer in the private sector who has 1 to 499 employees. So the law exempts employers that have 500 or more employees. In looking to determine how many employees you have, you look at the United States, District of Columbia, the U.S. territory, or possession. Employers with less than 50 employees may be partially exempted. And that partial exemption, and we'll cover that a little bit later on, only applies to certain aspects of the paid sick leave benefits, and moreover, only applies if providing the leave would jeopardize the viability of the business. Again, we'll talk about that a little bit more later. In calculating the number of employees that you have, you look at the number at the time that the leave is requested. The number of employees includes part-timers, temporary employees, employees on leave, even if it's paid leave or unpaid leave. Bottom line is if they're on your payroll, they're counted for getting under the 50 or over the 499. And if you are an employer that is hovering right around these numbers, you have 49 employees and want to exempt yourself from some of these provisions, you have to understand that if you bring on 2 more employees and now you have 51 employees, then each time thereafter that there's a request for leave, you are going to be covered. So keep that in mind when you're making hiring and layoff decisions. So with that, now that we know who is covered by the Emergency Paid Sick Leave Act, let's look at what leave is required under the law. For full-time employees, you have to provide 80 hours of paid sick leave. For part-time employees, it's as simple as paying them for the number of hours that they are scheduled to work. So within a 2-week period of time, the part-timers are regularly scheduled to work a total of 40 hours, then they're entitled to 40 hours of leave. In a situation where the part-timers have fluctuating hours, then you use an average for 2 weeks over a 6-month period of time. So if on average over a 6-month period of time looking back, they average 25 hours in 2 weeks, then they're entitled to 25 hours of paid sick leave under the Emergency Paid Sick Leave Act. It's very important to understand that this law is not retroactive from its April 1 of 2020 date. And what I mean by that is that if you provided any leave for qualifying reasons prior to April 1, it doesn't count against the entitlement of leave under the EPSLA. What I mean by this is that, for example, if you gave an employee 40 hours of leave prior to April 1 because they had COVID-19 symptoms, come April 1, they were still entitled to 80 hours, notwithstanding the fact that you had given them 40 hours for a qualifying reason beforehand. So with that, the next question that we have to answer is what qualifies employees for this new emergency paid leave under the law. The Act itself contains 6 qualifying reasons for emergency paid sick leave. The first one is the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. Now, I've underlined a couple of the terms here in that first paragraph, employee and quarantine or isolation order, because what constitutes an order applicable to the employee was a little unclear when the law first came out. And just to provide a little bit of background as to why that anomaly exists, normally when Congress passes legislation, especially in the employment arena, they provide a blueprint or an outline for what the law is going to cover, and it's up to the administrative agencies to then create rules and regulations regarding the interpretation and application of that new law. So when the Americans with Disabilities Act came into being, there was a 1-year period of time between its passage and its effective date to give the Department of Labor and the EEOC opportunity to issue regulations, fully vet them, and make sure that all of the questions were answered prior to the time that the law went into effect. The same thing happened when the Family and Medical Leave Act was passed. There was a lag time between the passage date and the date it went into effect, so the Department of Labor could vet and then issue regulations. Obviously, we're in a quite different situation nowadays with COVID-19, and this was an emergent situation that Congress found itself in, and we did not have that lag time between the passing of the legislation and the issuance of the regulations so that these regulations could be fully vetted. But in the regulations, there is some clarification with respect to these terms, employee and quarantine or isolation order. And what the Department of Labor has told us in their temporary regulations is that if the order causes the employer to shut down or reduce operations, which thereby causes the employee to be out of work, it doesn't qualify for emergency sick leave. Instead, the order that triggers this first qualifying reason for entitlement of this emergency paid sick leave has to apply to the employee or a class of employees that the employee is in. So, for example, when the governor issues the order saying that all people over 65 age or older are required to stay home, that is a state order that causes an individual not to be able to work. Additionally, by way of example, the governor's order directing individuals returning from New Jersey, New York, and Connecticut to self-quarantine for 14 days is also an order that's directed at a group of individuals and therefore would likely qualify for reason number one under the Emergency Paid Sick Leave Act. Number two, the employee has been advised by a healthcare provider to self-quarantine due to concerns relating to COVID-19. Number three, the employee is experiencing symptoms of COVID-19 and seeking medical diagnosis. Keep in mind that an employee saying to you that I'm not coming into work because I have a fever or I have a sore throat and I'm concerned is not enough. The employee actually has to be seeking a medical diagnosis to qualify for the leave under number three. With respect to qualifying reasons number one, number two, and number three, under the EPSLA, employees are entitled to be compensated at 100% of their regular rate of pay as defined under the FLSA. What is the regular rate of pay? It's the rate that you use for purposes of calculating overtime. And as I'm sure all of you on the call know, when you calculate overtime, it's 1.5 times that regular rate. So it's the one-time rate is what you have to use to compensate these individuals, not their base rate. There is a cap that exists under the law. That cap is $500 a day and $5,110 in the aggregate for each individual. So there is at least some relief under the law as far as how much you have to pay out to these individuals who qualify under the EPSLA for paid sick leave. Number four, the employee is caring for an individual who is subject to an order, quarantine order, or is self-quarantine. This is another one of those areas where the law itself has terms that can be interpreted in many, many different ways. And taking to its logical conclusion, individual could be somebody that you met yesterday on the street who you decided that you're going to provide care for. The Department of Labor clarified that in their temporary rule and regulations. And for purposes of qualifying reason number four, an individual is an immediate family member or a person residing in the employee's home or a person who the employee has a relationship with, such as it would create an expectation that the employee would care for them. It's clearly, and the Department of Labor regulations specifically say, it's not a person that the employee has no relationship with. Number five, the employee is caring for a son or daughter if the school or child daycare or child care provider is closed or unavailable due to COVID-19 concerns. As you can see, I underline for your consideration, son or daughter. Son or daughter is not just a biological son or daughter, but also includes an adopted child, a foster child, a stepchild, or any legal ward of the employee. School refers to any elementary or secondary school. And child care provider in the regulations, it's clear that it applies to licensed facilities. But this is one area where the Department of Labor decided to expand the definition of child care provider. And in those regulations, the child care provider doesn't have to be licensed or even compensated. It can be a family member or a friend who regularly cares for the child, even without any compensation. Number 6 is basically a catch-all that exists within the law. And the Department of Health and Human Services has the ability under the law to identify other conditions that would qualify for the emergency paid sick leave. To date, HHS has not issued any such additional conditions that would qualify for the leave. In each one of these circumstances, number 4, number 5, or number 6, the employee is entitled to 2/3 of his or her regular rate instead of the 100% of the regular rate under qualifying reasons 1, 2, and 3. And in this situation, the employee is capped at $200 a day instead of the $511 under qualifying reasons 1, 2, and 3. And in the aggregate capped at $2,000 per person instead of the $5,110 under qualifying reasons number 1, 2, and 3. It is important to understand that employees are only eligible for emergency paid sick leave when they either in-person work or telework is available for them. And out of all of the questions that I've been receiving over the last week or two with respect to the leave entitlement, this is the one that I get more than any others. If an employee is laid off, or the employee is furloughed, or the employee's hours are reduced, they are not entitled to emergency paid sick leave. And why is that? It's because when you laid off those individuals, or you furloughed them, or you reduced their hours, there was no work available for them, whether it's in-person work or telework. It doesn't matter that the unavailability of that work is because your business is subject to some type of shelter-in-place order, because you've been determined not to be an essential business, or because there's been a downturn in your business and you've made the difficult but necessary measures to reduce costs. I'm often asked the question, if I reduce an employee who normally works 40 hours to 20 hours a week, can they then use 20 hours or even the 80 hours of the emergency paid sick leave to make up for the reduction? The answer is no. Moreover, if you offer the employee a telework option, and the employee has that ability to work at home and declines to do so, they are not entitled to any of the emergency paid sick leave. Some of the rules regarding the usage of this leave: you cannot require employees to use accrued paid leave to substitute for the emergency paid leave under the law. If an employee comes to you and says, I need to take emergency paid sick leave for one of those 6 qualifying reasons that we've already discussed, you can't ask them to find a replacement to cover for them. That is your responsibility under the law. And you can't require them to burn their accrued paid leave prior to using their 80 hours of paid sick leave under the EPSLA. question came up with respect to the act as it was originally passed, whether or not you have to allow the use of intermittent leave. And what I mean by intermittent leave is allowing an employee to use a few hours at a time, or allowing them to use a day or two non-consecutively. The Department of Labor clarified this in their regulations. And the first and foremost point is that you as the employer do not have to allow the use of intermittent leave, period, end of story. However, you can allow for the intermittent use of leave under certain circumstances. And what you can do depends upon whether the employee is actually at work or is teleworking. If the employee is working out of your place of business, you can only allow them to use this paid sick leave intermittently for qualifying reason number 5, which is to care for a child. You are not allowed to allow them to use the intermittent leave for any of the other reasons. Why is that? It's because there's a recognition that if somebody is using emergency paid sick leave because they're having COVID-19 symptoms or because they're caring for somebody who's been diagnosed with COVID-19, the last thing you want them to do is coming in and out of your workplace every other day and potentially exposing your workforce to COVID-19. Whereas when it comes to caring for a child, that has, in theory, limited possibilities of infecting coworkers. Now, if the employees are teleworking, you don't have that same concerns about the individuals coming into your place of business. Therefore, if the employee is teleworking, you can allow them to use the intermittent leave for any of the 6 reasons set forth in the Emergency Paid Sick Leave Act. One of the big issues that we face with respect to this law is to what extent, if any, can you require documentation from the employee for purposes of allowing them to use leave under the law. There are certain documents that you can require of them. First and foremost, when it comes to sick leave, the first day of the sick leave, you have to just give it to them. Thereafter, you can enforce your normal sick leave rules, with the exception of the documentation. You can require things like daycare notices. However, can you require them to provide a doctor's note as a condition of providing the leave? The answer at this point in the regulations seems to be no. That could change over time. The IRS, believe it or not, is actually involved in the type of documentation that an employer can and should have to support the leave, and they may actually be issuing regulations clarifying it. However, at this point in time, the prevailing wisdom is that we can't require doctor's notes as a condition for the use of the 80 hours of sick leave. So what happens then if you decide you're not going to pay the sick leave that the employees are entitled to under the law? Or alternatively, you decide that you don't like the fact that somebody's taking the sick leave and you're going to fire them. Well, if you do that, you're subject to penalties. The Emergency Paid Sick Leave Act is enforced under the Fair Labor Standards Act. So it's as if you didn't pay the employees minimum wage or overtime, and they're entitled to the sick leave that you didn't pay them, reinstatement and back wages if you wrongly terminate them, liquidated damages for both, meaning a doubling of whatever money you owe them, attorney's fees, and with respect to the FLSA, there's always the possibility of individual liability for the decision makers. Now, the Department of Labor recognizes that this is all new and happening very fast, and they have announced that they are not going to be focusing on enforcement until April 17 of 2020, as long as you're acting in good faith to try to comply with the new law. Obviously, if you turn around and fire everybody that requests the leave, the non-enforcement decision by the Department of Labor is not going to apply to you. So, with that said, let's now turn our attention to the second of the two main employment-related sections of the SFCRA, namely the Emergency Family Medical Leave Expansion Act, or the EFMLEA. Now, unlike the Emergency Paid Sick Leave Act, the Emergency Paid Family Leave Expansion Act is based on an existing law. And that existing law is the Family Medical Leave Act. For those of you who might not be that familiar with the Family Medical Leave Act, in a nutshell, the pre-existing Family Medical Leave Act provides covered employees with up to 12 weeks of job-protected leave and a 12-month period for the birth or adoption of a child, to care for a spouse, child, or parent with a serious health condition, or for the employee's own serious health condition. There are also provisions in the Act for covered service members, but in a nutshell, that is the FMLA, and their well-established rules, regulations, and plenty of case law interpreting the Family Medical Leave Act. The EFMLEA adds a new category to the existing FMLA. So I gave you the three categories there. This adds a fourth, which is referred to as public health emergency leave. And the long and short of it is that this new category of FMLA leave applies where the employee is unable to work or telework because they need to care for the son or daughter under 18 years of age. Now, as I mentioned before, the Department of Labor went in and applied their own interpretation or application to the provisions of the Act itself. And notwithstanding the fact that the Act says son or daughter under the age of 18, the Department of Labor has actually expanded that definition to include a child over the age of 18 who has a physical or mental disability requiring care. The school has to be closed or the child care has to be unavailable. Child care provider has to be unavailable, basically following the same rules that we discussed with respect to qualifying reason number 5 under the Emergency Paid Sick Leave Act. And the closure or the unavailability has to be due to a public health emergency declared by a federal, state, or local authority. And in Florida, we have that, and we've had that for a while with respect to the school closures. And to some extent, the child care providers, even though in the governor's order that he issued on April 1 of 2020, there is a carve-out for child care providers under certain circumstances. The qualifying reasons for the expanded family medical leave are very similar to the qualifying reason number 5 under the emergency paid sick leave. It's important to understand that this new FMLA, this emergency FMLA or expanded FMLA, is not meant to cover employees who get COVID-19 or have to care for family members who get COVID-19. There may be circumstances under which the employees under those circumstances may be eligible for what I'll refer to as the normal family medical leave, depending upon the circumstances, assuming that you're an employer that's covered by the regular family and medical leave. So this really is a pretty narrow expansion of the existing Family Medical Leave Act. Coverage under the EFMLEA is similar to the Emergency Paid Sick Leave Act, but it's not identical. A covered employee is slightly different definition for the EFMLEA than the EPSLA. And in this regard, a covered employee for the expanded family medical leave is any employee who's worked for the employer a minimum of 30 days prior to the leave, as opposed to under the Sick Leave Act, it's anybody that works for you the minute they come on board. And this replaces the requirement under the regular FMLA that the employee work for 1 year and actually is paid for 1,250 hours prior to the leave. So what this means is that if you hire somebody on April 1, 30 days later, they are eligible to take the expanded FMLA. Covered employer is defined the same for purposes of the EFMLEA as it is under the Emergency Paid Sick Leave Act, the 1 to 499 employees, which replaces the requirement of the family medical leave for 50 or more employees working each day during each of the 20 or more work weeks in the year of or immediately preceding the request for leave. And like the EPSLA, the EFMLEA contains what's known as the small business exception, which applies to employers with less than 50 employees, which we'll talk about in just a couple of minutes. So what leave does the EFMLEA entitle a qualified employee to? Up to 12 weeks of job protected leave. The first 10 days of the leave under the Act is unpaid. The employee, at the employee's option, can substitute such paid leave, such as the EPSL leave, the Emergency Paid Sick Leave Act leave, those 80 hours. The employer cannot require substitution. Now, I'm saying that with the caveat that in the corrections to the DOL rule that were issued just this morning, there is some verbiage regarding that, and that still remains to be seen. We will be posting on our website an alert regarding the new or corrected regulations, and I would encourage you to, when you have a chance later today, to jump onto the website to see the posting to interpret the corrections to the Department of Labor rules. The remaining 10 weeks of paid, 10 weeks of FMLA are paid, and the employees are compensated at 2/3 of their regular rate, similar to the pay that they're entitled to under qualifying reason number 1 for the emergency paid sick leave, and that's capped at $200 a day or $10,000 per employee. The Department of Labor, in their temporary rules and regulations, answered one big unanswered question under the Act itself, and that is whether or not this 12 weeks were in addition to the 12 weeks that employees who are subject to the regular FMLA are entitled to, and the Department of Labor said no, they're not. That means is that if you're an FMLA covered employer and the employee has already taken 10 weeks of FMLA in their 12-month period for reasons under the regular FMLA, that means they only have 2 weeks available to them under the Emergency Family Medical Leave Expansion Act. They don't get an additional 2 weeks on top of that. I'm sorry, they don't get an additional 12 weeks on top of that. Some other provisions of note in the Emergency Family Medical Leave Expansion Act. The employee is required to give you notice when it's foreseeable, and the notice has to be as much as is practical under the circumstances. By now, pretty much everybody knows whether the school that their child goes to is closed and whether or not their caregiver is available. However, there can be circumstances under which the caregiver is currently available, but next week might not, and they have to give you as much notice as they can of that. Intermittent leave applies to EFMLEA only if the employer agrees to do so. Just like the regular FMLA, there are job reinstatement and job restoration rights upon the expiration of the leave. If you have 25 or more employees, then you follow the rules under the regular FMLA, and for other than key employees, who are the top 10% of the employees within the organization, you're required to return the individual to the same or equivalent position. An equivalent position is one that has the same benefits, pay, or other terms and conditions of employment. If you have less than 25 employees, then different rules apply to you with respect to reinstatement or job restoration. And in that case, you're required to return the person to the same position if that position still exists. If that position no longer exists due to economic conditions, then you can return them to an equivalent position. However, if after engaging in a good faith effort to find them an equivalent position, there is nothing available, you can go ahead and separate that individual. However, they have recall rights for 1 year, and you have to bring them back in if the position is reconstituted during that 1 year period of time. Enforcement under the EFMLEA, similar to the Emergency Paid Sick Leave Act. However, with respect to the EFMLEA, enforcement is under the FMLA provisions, not the Fair Labor Standards Act provisions. However, you're still required to provide and not interfere with an employee's entitlement to the expanded family medical leave, and you can't retaliate against individuals for taking or attempting to take the expanded FMLA. And if you do so, you're potentially on the hook for unpaid FMLA, reinstatement back wages at termination, liquidated damages, again, the doubling of the damages, and attorney's fees. There's a curious carve-out within the EFMLEA, and private lawsuits, meaning lawsuits brought by your employees or former employees, are only allowed against employees of 50 or more employees. If you have less than 50 employees, only the Department of Labor can bring an action against you. They can still sue you, so the suit's a suit at the end of the day. So it's not a carte blanche for employers of less than 50 employees to violate the law. And similarly, this provision is not going to be, well, I don't want to say it's not going to be enforced, but the DOL is not planning to take enforcement action until April 17, 2020 against you, so long as, again, you are attempting to comply in good faith with the law. If you're a covered employer, you're required to post notice of the employee rights. This is a link to the Department of Labor website and their poster. I suggest that you use this poster, and you should post it where you post your federal law on the one poster that has the non-discrimination and the rest. The small business exception. So, as I mentioned before, there's this exemption that exists in both the Paid Sick Leave Act and the Emergency or the Expanded FMLA. An employer with less than 50 can be exempt from providing paid sick leave and FMLA for child care. And it's important to understand that this is a carve-out just for qualifying reason number one under the Emergency Paid Sick Leave Act and the Expanded FMLA. Even if you have less than 50 employees, you are still covered and required to pay the emergency paid sick leave for the remaining 5 qualifying reasons under the Emergency Paid Sick Leave Act. The law itself and the DOL regulations allow an authorized officer of the business to make that determination on your behalf. There's no mechanism whereby you have to apply for this exemption. You can self-determine it, but you have to make sure that there's documents to support your position, payroll, P&L statements, and the rest. And basically, the bottom line is that providing the leave is going to raise expenses and obligations above what would allow you to operate at minimal capacity. The absence would pose a substantial risk because of the employee's specialized skill or knowledge or ability, or you're just plain not going to be able to find enough people to cover for the absences to keep your business up and running. To soften the blow of the Emergency Paid Sick Leave Act and the EFMLEA, the Congress and the Department of Labor and the IRS have provided for some type of tax relief. Now, I don't profess to be a tax attorney, and I would suggest that in applying these tax credits that you consult with a tax professional. But the bottom line is that within the Act itself, the payments that you make to the employees under the Emergency Paid Sick Leave Act and the EFMLEA are exempt from Social Security tax. In addition, under the Act itself, there is an offset that you're, or a setup that you're allowed against your quarterly Social Security taxes for the amounts of the emergency sick leave and the expanded FMLA that you pay. However, the IRS has actually expanded that in IR 2020-57, and according to the IRS, you can offset all of your federal income taxes, including Social Security, including withholding, Social Security, and Medicare, against your tax liability, meaning that at the end of the quarter, you can deduct from the amount that you have to pay to the government in taxes whatever you paid during that quarter for the emergency paid sick leave and the expanded FMLA. And according to the Department of Labor and the IRS, to the extent that you paid out more than you would have owed in taxes, you can apply for a refund, and the IRS will get that to you in an expedited manner, whatever that means. I suggest that you be on the lookout for further guidance from the IRS in this regard. Once again, if that comes out, we will be posting that on our website. And speaking of which, there are a number of areas that we haven't covered here today relating to COVID-19, such as the CARES Act and the small business loans and paycheck protection. And I would encourage you all to check out the website resources we have. We have a COVID-19 team that does nothing but monitor this stuff and issue updates and guidance, and it's all on our website for you. And I would check back every once in a while because we are updating this stuff on almost a daily basis. So with that, do we have any questions? Kristen, do we have any questions?
Not yet. I just typed for people to type in their questions if they have any.
Well, I know there are still a few people that are on here, and please, I encourage you, if you have a question, to ask it. I'm more than happy to answer it to the extent I can.
And thank you, Jeff, for this very informative presentation.
Not a problem. I guess we do have one question from one of the attendees. The question is that whether or not the emergency FMLA is something that is going to be permanent moving forward, or if it just is in place till 12/31 of 20. And the answer is that it's just in place till 12/31 of 20. Sherry,
Yeah.
you can answer this, but the question's been asked whether or not this is going to be on demand as a recording.
Yes, I'll answer that. We will have this recording available on the MACF website under our resources page, and it will also be available on the MACF YouTube channel. We'll have a link to that to send to everybody who is in attendance, and that link will also be available.
Super. I know that questions come up from time to time, and maybe as you hang out later in the day, you may think of some things that have spurred on some additional questions. This is my email address. Please feel free to shoot me over your questions. I'm happy to try to answer for you. So, actually, we have one question here. Can we clarify? Can you take either FMLA for 12 weeks or EFMLA for 12 weeks for the year 2020, or not both? So basically, you get 12 weeks, whether it's 12 weeks that you're going to use for the regular FMLA or 12 weeks that you're going to use for the EFMLA, or a combination of the two. You do not get 24 weeks. So as I was mentioning before, if you end up using all of your 12 weeks for regular FMLA, you don't get any additional FMLA leave under the Emergency Family Medical Leave Expansion Act. Hopefully answered that. Thank you. And so a question was asked as far as the filing for the tax credit. That's something that I would encourage you to work through your payroll service on that. They should be able to guide you on how to properly do that.
Are there any other questions?